Question 1. Strategic planning requires an insurance agency owner to consider potential liabilities arising from the actions of their licensed agents. Under U.S. state insurance laws, which of the following approaches best mitigates the agency's exposure to liability for an agent's misconduct? Option A. Delegating all oversight responsibilities to a single, senior agent without formal agency policies on supervision. Option B. Relying on individual agents to independently manage their compliance with all applicable insurance laws and regulations. Option C. Assuming that the agent's individual licenses and errors and omissions insurance policies are sufficient to cover all potential agency liabilities. Option D. Implementing a comprehensive agency compliance program that includes clear policies, regular agent training, and robust oversight of agent activities. The correct answer is D. Implementing a comprehensive agency compliance program that includes clear policies, regular agent training, and robust oversight of agent activities. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the vicarious liability principles applicable to insurance agency owners and managers under U.S. state insurance laws, specifically as they pertain to the actions of licensed agents. The core difficulty lies in distinguishing between direct negligence in supervision and the imputation of an agent's actions to the agency itself. Owners and managers must implement robust compliance programs and oversight mechanisms to mitigate the agency's exposure to liability arising from agent misconduct, while also understanding the limits of their responsibility. The correct approach involves the agency owner proactively establishing and enforcing clear agency policies and procedures that mandate ethical conduct, compliance with all applicable insurance laws and regulations, and regular training for all licensed agents. This includes implementing a system for reviewing agent activities, handling customer complaints promptly and effectively, and ensuring agents maintain proper licensing and continuing education. This approach is correct because it directly addresses the agency's duty of care in supervising its agents and demonstrates a commitment to regulatory compliance, thereby minimizing the likelihood of vicarious liability for the agent's wrongful acts. State insurance laws often hold agencies responsible for the actions of their licensed employees or representatives acting within the scope of their authority. By implementing strong internal controls and oversight, the agency owner can demonstrate due diligence and a good faith effort to prevent misconduct, which can be a defense against claims of direct negligence and may influence the extent of vicarious liability. An incorrect approach would be to assume that simply hiring licensed agents absolves the agency of responsibility for their actions. This fails to acknowledge the agency's legal and ethical obligation to supervise its agents and ensure compliance with regulatory requirements. Such an approach could lead to vicarious liability for the agent's errors or omissions, as well as potential direct liability for negligent supervision if the agency knew or should have known about the agent's problematic behavior. Another incorrect approach is to delegate all compliance responsibilities solely to the individual agents without any oversight or accountability from the agency management. While agents are individually licensed and responsible for their own conduct, the agency as a business entity has a responsibility to ensure its operations and its agents' activities adhere to legal and ethical standards. This abdication of oversight can expose the agency to significant liability. A third incorrect approach is to focus solely on the agency's financial performance without adequately investing in compliance infrastructure, agent training, or complaint resolution processes. While profitability is important, it cannot come at the expense of regulatory adherence and ethical conduct. Neglecting these areas creates a fertile ground for misconduct and subsequent legal repercussions for the agency and its owners/managers. The professional decision-making process for similar situations should involve a risk-based assessment of potential liabilities arising from agent conduct. This includes understanding the specific state insurance laws governing agency responsibility, developing and consistently applying a comprehensive compliance program, providing ongoing training and education to agents, establishing clear lines of communication and reporting for compliance issues, and conducting regular audits of agent activities and customer interactions. Proactive risk management and a commitment to ethical operations are paramount in protecting both the agency and its clients. Question 2. Performance analysis shows that an insurance agent is assisting a client in completing an application for a life insurance policy. During the conversation, the client mentions a recent diagnosis of a chronic but manageable health condition that they believe is not significant enough to affect their mortality risk. The client explicitly asks the agent to omit this information from the application, stating it would complicate the process and potentially increase premiums unnecessarily. The agent recalls that such conditions are typically considered material facts by insurers. What is the most ethically and legally sound course of action for the insurance agent? Option A. Proceed with the application without mentioning the health condition to the underwriting department, assuming the insurer will discover it if a claim arises. Option B. Agree to omit the health condition from the application as requested by the client, assuring them it is a minor issue that will not impact the policy. Option C. Advise the client that the health condition is a material fact and must be disclosed on the application, explaining that failure to do so could jeopardize the policy's validity and future claims. Option D. Inform the client that the health condition is not material and can be excluded from the application to simplify the process. The correct answer is C. Advise the client that the health condition is a material fact and must be disclosed on the application, explaining that failure to do so could jeopardize the policy's validity and future claims. Explanation. This scenario presents a professional challenge because it requires an insurance professional to balance the company's financial interests with the ethical obligation to uphold the principle of utmost good faith. The agent's knowledge of material fact that could impact the insurer's risk assessment, coupled with the applicant's misrepresentation, creates a conflict. The core of the challenge lies in determining how to respond to the applicant's request to omit this information, which directly implicates the principles of insurable interest, indemnity, and utmost good faith. The correct approach involves advising the applicant that the information is material and must be disclosed. This upholds the principle of utmost good faith, also known as *uberimi fidei*, which requires all parties to an insurance contract to act with honesty and disclose all material facts. Failure to do so can void the contract. By insisting on disclosure, the agent ensures that the insurer can accurately assess the risk and underwrite the policy appropriately, aligning with the principle of indemnity, which aims to restore the insured to their pre-loss financial position without profit. This approach also implicitly acknowledges the existence of an insurable interest, as the applicant is seeking coverage for a legitimate risk. An incorrect approach would be to agree to omit the information. This directly violates the principle of utmost good faith by participating in a misrepresentation. It undermines the insurer's ability to assess risk accurately, potentially leading to underpricing of the policy or denial of claims later, which contravenes the spirit of indemnity. Ethically, it is dishonest and could expose the agent and the company to regulatory sanctions. Another incorrect approach would be to proceed with the policy without mentioning the omission to the underwriting department. This is a passive form of misrepresentation and still violates utmost good faith. The agent is aware of a material fact that the insurer is not, and by not reporting it, they are allowing the contract to be formed on false pretenses. This could lead to claims disputes and reputational damage. A third incorrect approach would be to advise the applicant that the information is not material and can be omitted. This is a misjudgment of materiality and a failure to uphold the duty of utmost good faith. What seems insignificant to the applicant or even the agent might be crucial for the underwriter's risk assessment. The agent's role is to facilitate accurate disclosure, not to make subjective judgments about materiality on behalf of the insurer. The professional decision-making process for similar situations should involve 1. Identifying the core principles at play: insurable interest, indemnity, utmost good faith. 2. Recognizing any potential misrepresentations or non-disclosures of material facts. 3. Consulting internal company guidelines and underwriting manuals regarding materiality. 4. Clearly and honestly communicating to the applicant the requirement for full and truthful disclosure, explaining the implications of non-disclosure. 5. Escalating complex or uncertain situations to a supervisor or underwriting department for guidance. Question 3. Implementation of an insurance producer's actions, which deviate from explicit company underwriting guidelines, but are made in an effort to secure a policy for a client, raises questions about the principal's liability. If the agency owner consistently allowed this producer to make similar representations to clients in the past, and the client reasonably believed these representations were authorized. What is the most likely legal outcome regarding the agency's responsibility for the producer's actions? Option A. The agency is not liable because the producer's actions were solely for the producer's personal benefit, not for the agency's direct financial gain. Option B. The agency is likely liable because the producer acted with apparent authority, as the agency's past conduct created a reasonable belief in the client that the producer had the authority to make such representations. Option C. The agency is only liable if the producer had express written permission from the agency owner to deviate from the underwriting guidelines in this specific instance. Option D. The agency is not liable because the producer explicitly violated company underwriting guidelines, which negates any form of agency authority. The correct answer is B. The agency is likely liable because the producer acted with apparent authority, as the agency's past conduct created a reasonable belief in the client that the producer had the authority to make such representations. Explanation: this scenario is professionally challenging because it requires an insurance professional to navigate the complex legal doctrine of respondit superior, specifically how a principal, the insurance agency, can be held liable for the actions of its agent, the producer. The core of the challenge lies in determining the scope of the agent's authority and whether their actions, even if unauthorized or wrongful, were performed within the course and scope of their employment or agency relationship. Misjudging this can lead to significant financial and reputational damage for the agency. The correct approach involves a thorough understanding of the principles of agency law as applied to insurance. This includes distinguishing between actual authority, express or implied, and apparent authority. If the producer acted with apparent authority, meaning the principal's conduct led a third party, the applicant, to reasonably believe the producer had the authority to act, the principal can be bound by the agent's actions, even if those actions exceeded their actual authority. This is rooted in fairness and preventing principals from benefiting from the misrepresentations of their agents while disclaiming responsibility. The regulatory framework for insurance professionals emphasizes ethical conduct and consumer protection, which aligns with holding principals accountable for the actions of their agents when those actions create a reasonable reliance by the consumer. An incorrect approach would be to solely focus on whether the producer had express written authorization for the specific action. While express authority is a clear basis for liability, its absence does not automatically absolve the principal. Failing to consider apparent authority, which arises from the principal's manifestations to the third party, is a significant regulatory and ethical failure. It ignores the principle that a principal should not be able to escape liability when their own conduct has led a third party to reasonably believe an agent possesses certain authority. Another incorrect approach is to assume that any deviation from company policy or procedure automatically shields the principal from liability. While policy violations are relevant, the ultimate test is whether the agent was acting within the scope of their employment or agency, even if they did so improperly. Ignoring the potential for vicarious liability based on the overall nature of the agent's duties and the context of their actions is a critical oversight. Professionals should employ a decision-making framework that begins with identifying the nature of the agent's action and the applicant's perception of the agent's authority. This involves assessing the principal's, agency's, conduct that might have led the applicant to believe the agent had the authority to make the representations or promises. The professional should then consider whether the agent's actions, even if unauthorized, were undertaken in furtherance of the principal's business or for the principal's benefit, and whether the applicant reasonably relied on those actions. This framework prioritizes a holistic view of the agency relationship and the impact on the consumer, aligning with the ethical and regulatory imperative to protect policyholders. Question 4. Which approach would be most effective for an insurance professional to determine if a legally binding insurance contract has been formed, considering the fundamental elements of offer, acceptance, consideration, capacity, and legality within the U.S. regulatory framework? Option A. Prioritizing the insured's perceived need for coverage and the insurer's willingness to issue a policy. Option B. Assuming contract validity based on common industry practices and the insurer's intent to provide coverage. Option C. Focusing solely on the presence of a signed policy document and the initial premium payment. Option D. A comparative analysis of the proposed insurance agreement against the established legal definitions of offer, acceptance, consideration, capacity, and legality. The correct answer is D. A comparative analysis of the proposed insurance agreement against the established legal definitions of offer, acceptance, consideration, capacity, and legality. Explanation. This scenario presents a professional challenge because it requires an insurance professional to discern the presence of all essential elements of a valid contract within a complex business transaction, specifically in the context of an insurance policy. Misinterpreting any of these elements can lead to disputes, regulatory scrutiny, and financial loss. The professional must apply a systematic and thorough analytical framework to ensure compliance with the Business Law for Insurance Professionals exam, CPCU 530, curriculum, which emphasizes the foundational principles of contract law as they apply to insurance. The correct approach involves a comparative analysis of the proposed insurance agreement against the established legal definitions of offer, acceptance, consideration, capacity, and legality. This method is correct because it directly addresses the core requirement of contract formation. By dissecting the transaction into its constituent contractual elements and evaluating each against legal standards, a professional can definitively determine if a legally binding contract exists. This aligns with the regulatory framework for insurance professionals, which mandates adherence to contract law principles to ensure fair dealings and policy validity. Specifically, it requires identifying a clear offer, e.g., the policy application and premium, a corresponding acceptance, e.g., the insurer issuing the policy, valid consideration, e.g., the premium paid by the insured for the insurer's promise to indemnify, legal capacity of both parties to contract, e.g., not minors or mentally incapacitated, and a legal purpose for the contract, e.g., not for an illegal activity. An incorrect approach would be to focus solely on the presence of a signed document and premium payment. This is a regulatory and ethical failure because it overlooks other critical elements. While a signed document and payment are often indicators of offer and acceptance, they do not inherently guarantee the presence of consideration, capacity, or legality. For instance, a policy issued to a minor lacking capacity or for an illegal purpose would not be a valid contract, regardless of signatures and payments. Another incorrect approach would be to assume contract validity based on industry custom alone. While industry practices are important, they cannot override fundamental legal requirements for contract formation. Relying solely on custom without verifying the presence of all essential elements is a significant ethical lapse and a failure to uphold legal obligations. A third incorrect approach would be to prioritize the insurer's intent to provide coverage over the insured's legal obligations. Contract law is bilateral. Both parties must meet their contractual obligations and possess the legal standing to enter into the agreement. The professional decision-making process for similar situations should involve a structured element-by-element review of the proposed contract. This begins with clearly identifying the parties and their roles. Then, each element of a valid contract, offer, acceptance, consideration, capacity, legality, must be systematically assessed. For each element, the professional should ask specific questions. Is there a clear offer? Was it unequivocally accepted? Is there a bargain for exchange of value consideration? Do both parties have the legal ability to enter into a contract? Capacity. Is the purpose of the contract legal? This methodical approach ensures that all legal requirements are met, thereby protecting both the insured and the insurer and maintaining regulatory compliance. Question 5. The analysis reveals that an insurance company operating under U.S. state insurance regulations has consistently met the statutory minimum capital requirements for the past 5 years. However, recent internal risk assessments indicate a significant increase in the company's exposure to complex derivative instruments used for hedging, which are not explicitly detailed in the standard statutory reporting. Which of the following approaches best demonstrates compliance with solvency regulation under this scenario? Option A. The insurer should continue to rely on meeting the statutory minimum capital requirements, as these are the legally mandated thresholds for solvency. Option B. The insurer should immediately recalculate its risk-based capital, RBC, using the applicable NAIC Model Act framework, incorporating the specific risks associated with its derivative portfolio, and adjust its capital accordingly to ensure it meets the calculated RBC target. Option C. The insurer should assume that its recent positive financial audit sufficiently covers any potential solvency issues, including those arising from complex financial instruments. Option D. The insurer should wait for a specific directive from the state insurance department or the NAIC before taking any action regarding its capital levels. The correct answer is B. The insurer should immediately recalculate its risk-based capital, RBC, using the applicable NAIC Model Act framework, incorporating the specific risks associated with its derivative portfolio, and adjust its capital accordingly to ensure it meets the calculated RBC target. Explanation: this scenario presents a professional challenge because it requires an insurance professional to navigate the complex and evolving landscape of solvency regulation, specifically concerning the application of risk-based capital (RBC) requirements. The professional must understand not only the letter of the law, but also the intent behind these regulations, which is to ensure the financial stability of insurers and protect policyholders. Misinterpreting or misapplying these rules can lead to regulatory sanctions, reputational damage, and ultimately, harm to the insurance company and its customers. The correct approach involves a thorough understanding of the specific RBC framework applicable in the relevant U.S. jurisdiction, as mandated by the CPCU 530 exam scope. This includes recognizing that RBC requirements are designed to be dynamic, adjusting to the insurer's risk profile. Therefore, an insurer must continuously monitor its risk exposures and ensure its capital levels are commensurate with those risks, as defined by the applicable state insurance department's regulations and any NAIC model laws that have been adopted. This proactive and comprehensive assessment aligns with the regulatory objective of maintaining solvency and preventing insolvencies. An incorrect approach would be to rely solely on statutory minimum capital requirements without considering the insurer's actual risk profile. Statutory minimums are a baseline, but RBC is intended to go beyond this, requiring capital to cover a broader range of potential losses. Failing to conduct regular, robust risk assessments and adjust capital accordingly would be a significant regulatory failure, potentially leading to an insurer being undercapitalized for its specific risks. Another incorrect approach would be to assume that a recent positive financial audit automatically equates to solvency under RBC rules. Audits focus on financial reporting accuracy, while RBC focuses on the adequacy of capital to absorb unexpected losses. These are distinct but related concepts, and one does not guarantee compliance with the other. Finally, an incorrect approach would be to delay or ignore regulatory guidance or directives concerning solvency. Regulators provide interpretations and updates to ensure consistent application of RBC rules, and failure to heed these can be seen as a deliberate disregard for regulatory oversight. Professionals should approach solvency regulation by first identifying the specific U.S. state, S, in which the insurer operates in the applicable RBC framework, e.g., Life RBC, Health RBC, P&C RBC. They should then consult the relevant statutes, regulations, and NAIC model laws. A key step is to understand the components of the RBC formula and how different risk factors, underwriting, credit, market, operational, are calculated. Regular internal risk assessments, stress testing, and scenario analysis are crucial to ensure capital adequacy. Professionals must also stay informed about regulatory updates and guidance from state departments of insurance and the NAIC. When in doubt, seeking clarification from legal counsel or regulatory bodies is a prudent professional decision-making step. Question 6. Cost-benefit analysis shows that offering a future discount on premiums for a customer's past loyalty, without any new action or commitment from the customer at the time of the promise, is being considered by an insurance agency. The agency's management is debating whether this promise creates a legally binding obligation. Which of the following best describes the legal status of the agency's promise regarding consideration? A. The promise is supported by sufficient consideration because the customer's past loyalty represents a benefit to the agency. B. The promise is supported by sufficient consideration as the agency is conferring a benefit upon the customer. C. The promise is not supported by sufficient consideration because past loyalty is not a bargain for exchange for the future discount. D. The promise is supported by sufficient consideration as the agency has a moral obligation to reward loyal customers. Option A. The promise is supported by sufficient consideration, as the agency has a moral obligation to reward loyal customers. Option B. The promise is not supported by sufficient consideration because past loyalty is not a bargain for exchange for the future discount. Option C. The promise is supported by sufficient consideration because the customer's past loyalty represents a benefit to the agency. Option D. The promise is supported by sufficient consideration, as the agency is conferring a benefit upon the customer. The correct answer is C. The promise is supported by sufficient consideration because the customer's past loyalty represents a benefit to the agency. Explanation. This scenario is professionally challenging because it requires distinguishing between a legally sufficient bargain for exchange and a gratuitous promise, which is a fundamental concept in contract law, particularly relevant to insurance contracts. The professional must apply the legal definition of consideration to determine if a valid contract exists or if a promise is unenforceable due to lack of legal value. Careful judgment is required to avoid misinterpreting actions or statements as legally binding when they are not, or vice versa. The correct approach involves identifying a bargain for exchange where each party gives up something of legal value or incurs a legal detriment. This could be the insured paying a premium in exchange for the insurer's promise to pay a claim, or the insurer providing a policy in exchange for the insured's agreement to certain terms. The legal justification stems from common law principles governing contract formation, which are foundational to insurance law. For a contract to be enforceable, there must be offer, acceptance, and consideration. Consideration is the price of the promise, meaning each party must receive a benefit or suffer a detriment. Past consideration or a mere promise to make a gift generally does not constitute sufficient consideration. An incorrect approach would be to consider a promise to make a gift as legally binding consideration. This fails because a gift promise lacks the bargain for exchange element. The promiser receives nothing of legal value in return for their promise. This is a gratuitous promise and is generally unenforceable as a contract. Another incorrect approach is to view past actions as sufficient consideration for a new promise. This is incorrect because consideration must be given in exchange for the promise being made, not for something that has already been done. The law generally does not recognize past consideration as valid. Finally, an approach that considers a moral obligation as sufficient consideration is also incorrect. While moral obligations can be compelling, they do not typically meet the legal standard of a bargain for exchange of legal value. Professionals should approach such situations by first identifying the promises made by each party. Then, they must analyze whether each promise is supported by a bargain for exchange of legal value. This involves asking, what did each party give up or agree to do in return for the other party's promise? If a clear exchange of legal detriment or benefit is present, consideration likely exists. If a promise is made without any corresponding legal detriment or benefit being given in return, or if the purported consideration is something that has already occurred or is merely a moral obligation, then consideration is likely insufficient, and the promise may not be legally enforceable. Question 7. Risk assessment procedures indicate that an insurance company, currently licensed and operating in State A, is planning to expand its sales operations into State B. The company has a valid insurance producer license in state and believes this license, along with its corporate charter, should permit it to solicit and sell insurance policies to residents of State B. Which of the following approaches best aligns with U.S. state-based insurance regulatory requirements for licensing? Option A. Proactively identify and secure the appropriate non-resident insurance producer licenses in State B for all individuals and entities that will be soliciting business there. Option B. Proceed with sales operations in State B, assuming that a license in State A and a valid corporate charter are sufficient to conduct business in other states. Option C. Rely solely on the advice of the company's legal counsel regarding the necessity of additional licenses, without independently verifying State B's specific licensing requirements. Option D. Begin sales operations in State B and initiate the process of obtaining non-resident licenses in State B only after the first policy is sold. The correct answer is A. Proactively identify and secure the appropriate non-resident insurance producer licenses in State B for all individuals and entities that will be soliciting business there. Explanation. This scenario is professionally challenging because it requires an insurance professional to navigate the complexities of interstate insurance licensing, which is governed by a patchwork of state-specific regulations. The core challenge lies in understanding that, while some aspects of insurance business may appear uniform, the authority to solicit, negotiate, and sell insurance products is strictly territorial and requires specific authorization in each state where business is conducted. Failure to comply can lead to severe penalties, including fines, license revocation, and reputational damage. Careful judgment is required to ensure all necessary licenses are obtained and maintained before engaging in any insurance-related activities in a new jurisdiction. The correct approach involves proactively identifying and securing the appropriate non-resident insurance producer licenses in all states where the insurance company intends to conduct business. This demonstrates a commitment to regulatory compliance and ethical conduct. Specifically, the National Association of Insurance Commissioners, NAIC, model laws and the licensing requirements of individual states mandate that an individual or entity must be licensed in a state to act as an insurance producer there. Obtaining non-resident licenses ensures that the company is authorized by each state's Department of Insurance to engage in the business of insurance, thereby adhering to the principle of territorial jurisdiction and protecting consumers within those states. An incorrect approach would be to assume that a license in one state automatically grants authority in others. This overlooks the fundamental principle of state-based insurance regulation in the United States. Engaging in business in a state without the required non-resident license constitutes a violation of that state's insurance laws, potentially leading to penalties for transacting insurance without a license. Another incorrect approach would be to rely solely on the advice of legal counsel without independently verifying the licensing status and requirements in each relevant state. While legal counsel is invaluable, the ultimate responsibility for ensuring compliance rests with the insurance company and its producers. This approach risks misinterpretation or incomplete advice, leaving the company vulnerable to regulatory action. A third incorrect approach would be to delay obtaining non-resident licenses until after business operations have commenced in a new state. This is a reactive and non-compliant strategy. It exposes the company to immediate regulatory scrutiny and potential penalties from the outset of its operations in that jurisdiction. The professional decision-making process for similar situations should begin with a thorough understanding of the geographic scope of intended business operations. For each state identified, the insurance professional must research that state's specific insurance producer licensing requirements, paying close attention to rules for non-resident applicants. This research should be conducted through the individual state's Department of Insurance website or by contacting the department directly. The company should then initiate the licensing application process for all relevant producers and entities in a timely manner, ensuring that all required documentation and fees are submitted accurately and completely. Ongoing monitoring of license renewal dates and changes in state regulations is also crucial for maintaining compliance. Question 8. Governance review demonstrates that a director of an insurance company, who also holds a significant personal investment in a technology firm that provides essential IT services to the insurance industry, is scheduled to vote on a proposal to award a multi-year exclusive contract to that technology firm. The director believes that awarding this contract will enhance the technology firm's value, thereby increasing their personal investment, and also argues that the technology firm's services are superior and will ultimately benefit the insurance company. Which of the following approaches best upholds the director's fiduciary duties? Option A. The director should vote in favor of the proposal, asserting that their personal investment will lead to greater company value and that their vote reflects their belief in the technology firm's superior services. Option B. The director should proceed with voting on the proposal without disclosing their personal investment, as their vote is a private decision and their personal financial interest is not a concern for the board. Option C. The director should vote in favor of the proposal, arguing that as a significant shareholder, their personal interests are inherently aligned with the company's, thus negating any conflict of interest. Option D. The director should disclose their personal investment in the technology firm to the board and recuse themselves from voting on the contract proposal. Correct answer is D. The director should disclose their personal investment in the technology firm to the board and recuse themselves from voting on the contract proposal. Explanation. This scenario is professionally challenging because it involves a conflict between the financial interests of a director and the fiduciary duties owed to the corporation and its shareholders. Corporate officers and directors are entrusted with managing the company's affairs and are legally bound to act in the best interests of the corporation. This requires them to avoid self-dealing and to prioritize the company's welfare over personal gain. The core of the challenge lies in discerning when a director's personal business dealings cross the line from permissible independent activity to a breach of fiduciary duty, specifically the duty of loyalty. The correct approach involves a director recusing themselves from any decision-making processes where their personal interests might conflict with the corporation's interests. This aligns with the duty of loyalty, which mandates that directors act in good faith and in the best interests of the corporation, avoiding self-dealing and conflicts of interest. By abstaining from voting and disclosing the potential conflict, the director upholds transparency and ensures that decisions are made solely for the benefit of the corporation and its shareholders, free from undue personal influence. This practice is a cornerstone of corporate governance and is implicitly supported by common law principles governing fiduciary relationships, which are foundational to business law for insurance professionals. An incorrect approach would be to vote in favor of the proposal, arguing that their personal investment would ultimately benefit the company through increased market activity. This fails to recognize that the duty of loyalty requires directors to act without personal bias, even if they believe their personal gain might indirectly benefit the company. The potential for personal profit creates an inherent conflict that cannot be overcome by a subjective belief in overall benefit. Another incorrect approach would be to proceed with the vote without disclosing the personal investment, believing that their vote is a private matter and their personal financial interest is irrelevant to their directorial responsibilities. This violates the duty of loyalty by failing to disclose a material conflict of interest. Transparency is crucial in corporate governance, and withholding information about personal stakes in decisions before the board is a breach of trust. Finally, an incorrect approach would be to argue that as a significant shareholder, their personal interests are inherently aligned with the company's, and therefore, no conflict exists. While shareholder interests and director duties often overlap, a director's fiduciary obligations extend beyond their personal shareholding. They are entrusted with a position of trust that requires them to act impartially, even when their personal financial situation might be impacted by corporate decisions. The duty of loyalty specifically addresses situations where personal interests diverge from the corporation's best interests, regardless of overall shareholding. The professional decision-making process for similar situations should begin with identifying any potential personal interests that could influence a decision. This should be followed by a thorough assessment of whether these interests create a conflict with the director's fiduciary duties, particularly the duty of loyalty. If a conflict is identified, the professional course of action is to disclose the conflict to the board and recuse oneself from any discussion or vote on the matter. This proactive approach ensures compliance with legal and ethical obligations and safeguards the integrity of corporate governance. Question 9. The evaluation methodology shows that an insurance agent, while advising a client on a complex commercial property insurance policy, provided information that was technically accurate but failed to highlight certain exclusions that were highly relevant to the client's specific business operations. Subsequently, the client experienced a significant loss that was not covered by the policy due to these exclusions. The client is now alleging that the agent's advice constituted negligence. Which of the following approaches best reflects the necessary legal analysis to determine if negligence occurred? Option A. Conclude that negligence occurred because the client suffered a significant uncovered loss after receiving advice from the agent. Option B. Determine if the agent owed a duty of care to the client. If the agent's advice fell below the standard of a reasonably prudent insurance agent, if this breach directly caused the client's uncovered loss, and if the client suffered quantifiable damages as a result. Option C. Focus on the fact that the information provided by the agent was technically accurate, and therefore no negligence could have occurred, regardless of the outcome for the client. Option D. Assess whether the agent's advice was the sole reason for the client's loss, without considering if the agent's conduct deviated from the expected professional standard. The correct answer is B. Determine if the agent owed a duty of care to the client. If the agent's advice fell below the standard of a reasonably prudent insurance agent, if this breach directly caused the client's uncovered loss, and if the client suffered quantifiable damages as a result. Explanation. The evaluation methodology shows that a thorough understanding of negligence principles is crucial for insurance professionals, as their actions and advice can have significant legal and financial consequences for clients and the insurer. This scenario is professionally challenging because it requires distinguishing between a mere unfortunate event and a situation where a breach of duty of care has led to quantifiable damages, necessitating a nuanced application of legal principles. The correct approach involves a systematic analysis of the four elements of negligence: duty of care, breach of duty, causation, and damages. Professional must first determine if a duty of care was owed by the insurance professional to the client. This duty often arises from the professional relationship and the reliance placed upon the professional's expertise. Next, they must assess whether the professional's conduct fell below the standard of care expected of a reasonably prudent insurance professional in similar circumstances. This is the breach of duty. Following that, the professional must establish a causal link between the breach and the client's losses, meaning the damages would not have occurred but for the breach, and the damages were a foreseeable consequence. Finally, the existence and extent of actual damages must be proven. This structured approach ensures all legal requirements are met before concluding negligence. An incorrect approach would be to focus solely on the client's loss without establishing a breach of duty. This fails to recognize that not all financial losses are attributable to professional negligence. Some may be due to market fluctuations, inherent risks of the insured activity, or other factors beyond the professional's control. Another incorrect approach is to assume a breach of duty based on a negative outcome, without rigorously examining the professional's actions against the established standard of care. This overlooks the possibility that the professional acted reasonably, but the outcome was still unfavorable. Furthermore, an approach that ignores the requirement of causation, concluding negligence simply because a duty was owed and damages occurred, is flawed. It fails to demonstrate that the professional's specific actions or omissions directly led to the client's harm. The professional decision-making process for similar situations should involve a step-by-step evaluation of each element of negligence. Professionals should document their advice and actions meticulously, maintain professional competence through ongoing education, and adhere to ethical guidelines. When faced with a potential claim, they should consult with legal counsel to ensure a proper legal analysis is conducted, rather than making assumptions based on the client's distress or the severity of the loss. Question 10. Consider a scenario where a client verbally requests immediate temporary auto insurance coverage from an insurance agent and provides the agent with a check for the premium. The agent accepts the check, verbally confirms that coverage is in effect, and begins the process of issuing a formal policy. Later, the client is involved in an accident before receiving the written policy. Based on U.S. contract law principles relevant to insurance, what type of contract was most likely formed? Option A, a unilateral contract. Option B, a bilateral implied-in-fact contract. Option C, a bilateral express contract. Option D, an implied-in-law contract. The correct answer is C, a bilateral express contract. Explanation: this scenario is professionally challenging because it requires the insurance professional to accurately classify a contract based on the actions and communications of the parties involved, rather than a clearly written document. Misclassification can lead to significant legal and financial repercussions, including potential breach of contract claims and regulatory penalties. Careful judgment is required to discern the intent and agreement between the parties. The correct approach involves recognizing that the insurance agent's actions, in response to the client's request and the subsequent payment, created a binding agreement. This scenario exemplifies a bilateral contract because there was an exchange of promises. The client promised to pay the premium, and the agent, by accepting the payment and initiating coverage, promised to provide insurance protection. Furthermore, the agreement, though not fully documented in writing at the outset, became an express contract through the explicit verbal request for coverage and the agent's verbal confirmation and acceptance of payment. The subsequent actions solidify this express agreement. This aligns with general contract law principles applicable in the U.S., where an offer, client's request and payment, and acceptance, agent's action, form a valid contract. An incorrect approach would be to solely focus on the absence of a signed policy document as proof of no contract. This overlooks the possibility of implied contracts or the formation of express contracts through verbal agreements and subsequent conduct. In many U.S. jurisdictions, verbal agreements for insurance can be binding, especially when supported by partial performance payment and the agent's actions, classifying this as a unilateral contract, where acceptance is through performance alone, would be inaccurate because there was a clear exchange of promises, bilateral, and explicit communication express. Another incorrect approach would be to consider it an implied-in-fact contract based solely on industry custom, without acknowledging the explicit verbal request and acceptance. While industry custom can inform contract interpretation, the direct communication here establishes an express agreement. Professionals should approach such situations by first identifying the core elements of contract formation: offer, acceptance, consideration, and intent to be bound. They should then analyze the communications and actions of all parties to determine if these elements are present. In the absence of a fully executed written contract, it is crucial to consider verbal agreements, conduct, and the reasonable expectations of the parties. Consulting with legal counsel when in doubt about contract enforceability is a prudent professional decision-making step. Question 11. The audit findings indicate that a commercial property insurer, operating under U.S. state law, has denied a significant claim for business interruption losses due to a covered peril, citing an interpretation of the policy language that differs from the policyholder's reasonable understanding and industry practice. The policyholder has incurred substantial financial losses and is threatening legal action, alleging a breach of contract. Insurer's Claims Department is considering several potential responses. Which of the following approaches best aligns with the insurer's legal and regulatory obligations in this situation? Option A. Conduct a thorough review of the policy language, relevant case law, and state insurance regulations to determine if a breach of contract has occurred, and if so, to calculate and offer compensatory damages that reasonably reflect the policyholder's proven losses, while also exploring the possibility of other equitable remedies if appropriate. Option B. Offer a settlement amount that is significantly less than the documented business interruption losses, arguing that the policy language is ambiguous and the insurer's interpretation should prevail to limit its exposure. Option C. Deny any further communication with the policyholder and rely solely on the initial denial, asserting that the policyholder's interpretation is not supported by the contract. Option D. Immediately initiate litigation to seek a declaratory judgment on the interpretation of the policy language, without first attempting to negotiate a resolution or offering any form of compensation. Correct answer is B. Offer a settlement amount that is significantly less than the documented business interruption losses, arguing that the policy language is ambiguous and the insurer's interpretation should prevail to limit its exposure. Explanation: the audit findings indicate a potential breach of contract by a commercial insurer regarding a large property damage claim. This scenario is professionally challenging because it requires a nuanced understanding of contract law principles as applied to insurance, specifically the remedies available for a breach. The insurer must assess the financial implications of various remedies while adhering to regulatory obligations and ethical duties to the policyholder. Careful judgment is required to balance the insurer's financial interests with its contractual and regulatory responsibilities. The correct approach involves a thorough legal analysis to determine if a breach has occurred, and if so, to evaluate the most appropriate remedy under the applicable U.S. state law governing insurance contracts. This would typically involve considering compensatory damages to make the policyholder whole, as well as potentially other remedies if warranted by the specific circumstances and governing law. The regulatory framework for insurance professionals, particularly concerning fair claims handling practices and contractual obligations, mandates that insurers act in good faith and fulfill their contractual promises. Failure to do so can result in regulatory sanctions, litigation, and reputational damage. An approach that focuses solely on minimizing the insurer's payout without a proper assessment of the breach and the policyholder's entitlement to damages would be a regulatory and ethical failure. This overlooks the insurer's duty to indemnify the insured for covered losses as per the contract. Another incorrect approach would be to offer a remedy that is not legally permissible or is insufficient to compensate the policyholder for their actual losses, thereby violating principles of contract law and fair claims practices. Furthermore, ignoring the possibility of equitable remedies like specific performance, if applicable and appropriate under the law for certain types of insurance contracts, though less common for standard property claims, would represent a failure to consider all available legal avenues to rectify the breach. Professionals should employ a decision-making framework that begins with a comprehensive review of the insurance contract and all relevant facts. This should be followed by a legal assessment of whether a breach has occurred. If a breach is identified, the next step is to evaluate the available remedies under the governing law, prioritizing those that aim to make the injured party whole, compensatory damages. This assessment must also consider any specific state insurance regulations regarding claims handling and remedies. Ethical considerations, such as acting in good faith and with fairness towards the policyholder, must guide the selection and implementation of the chosen remedy. Question 12. The monitoring system demonstrates a novel approach to risk assessment within the insurance underwriting process, utilizing proprietary algorithms and a distinct user interface. The company has developed this system internally. Which of the following best represents the most prudent approach to managing the intellectual property aspects of this monitoring system? Option A. Immediately file for patent protection on the entire monitoring system, including the user interface, without first assessing existing patents or the copyright status of the code. Option B. Focus solely on protecting the software code through internal documentation, as this is the primary asset, and disregard potential patent issues for the business method or trademark concerns for the system's branding. Option C. Assume all internally developed software and associated business processes are protected by copyright and are free from third-party patent or trademark infringement, and proceed with full deployment. Option D. Conduct a comprehensive review of the system's software code for copyright protection, research the patentability of the underlying business method, and perform a trademark search for the system's name and interface elements to ensure no infringement and to identify potential protection for the company's own IP. The correct answer is C. Assume all internally developed software and associated business processes are protected by copyright and are free from third-party patent or trademark infringement, and proceed with full deployment. Explanation. This scenario is professionally challenging because it requires an insurance professional to navigate the complex interplay between intellectual property rights and the practicalities of business operations, specifically in the context of developing and utilizing proprietary software. The core challenge lies in ensuring compliance with intellectual property laws while fostering innovation and efficient business practices. A careful judgment is required to balance the protection of intellectual assets with the need for operational flexibility and the avoidance of infringement. The correct approach involves a thorough understanding of patent, copyright, and trademark law as it applies to software and business processes. Specifically, it requires recognizing that while software code is generally protected by copyright, business methods, or processes themselves might be patentable if they meet specific criteria. Furthermore, the use of distinctive branding elements in the software's interface or marketing materials would fall under trademark protection. The professional must ensure that the company's development and use of the monitoring system do not infringe on existing patents, copyrights, or trademarks held by others, and that the company's own intellectual property in the system is adequately protected. This involves due diligence, legal consultation when necessary, and clear internal policies regarding IP. An incorrect approach would be to assume that all software developed internally is automatically free from infringement concerns, or that business processes embedded in software are not subject to patent protection. For instance, if the monitoring system incorporates a novel and non-obvious business method that is already patented by a competitor, using it without a license would constitute patent infringement. Similarly, if the software utilizes copyrighted code snippets from third-party libraries without proper licensing, it would be copyright infringement. Another failure would be to overlook the trademark implications of the system's name or logo if they are confusingly similar to existing trademarks in the insurance industry, leading to potential trademark infringement. The professional decision-making process for similar situations should involve a proactive risk assessment. This includes 1. Identifying all intellectual property elements involved in the system, code, algorithms, business methods, branding. 2. Conducting thorough searches to determine if these elements infringe on existing third-party IP rights. 3. Consulting with legal counsel specializing in intellectual property law to assess patentability, copyright validity, and trademark registrability and potential infringement risks. 4. Implementing robust internal IP policies and training for employees involved in development and deployment. 5. Securing appropriate licenses or clearances for any third-party IP used. 6. Taking steps to protect the company's own IP through registration and enforcement. Question 13. The performance metrics show a significant increase in underwriting losses for a particular line of business. The underwriting department is recommending a broad non-renewal of policies in specific geographic areas identified as high risk, citing concerns about escalating claims frequency and severity. The marketing department is concerned about the potential negative impact on customer retention and brand perception if a large number of policyholders receive non-renewal notices. The agent force is also expressing apprehension about the potential for increased policyholder complaints and the difficulty in placing renewed business with other carriers. The company is based in a state that has specific statutes governing the non-renewal of insurance policies, including requirements for notice periods and permissible reasons for non-renewal. Which of the following actions best represents the legally and ethically sound approach for the insurance company to take regarding the non-renewal of these policies? Option A. Immediately non-renew all policies in the identified high-risk geographic areas without prior notice to policyholders to prevent further exposure to potential losses and address any regulatory inquiries later. Option B. Issue non-renewal notices to all policyholders in the identified high-risk geographic areas, citing general underwriting concerns, and provide the minimum notice period required by state law. Option C. Conduct a detailed review of individual policy performance within the identified high-risk geographic areas, applying specific, objective underwriting criteria to determine which policies meet the criteria for non-renewal, and then issue non-renewal notices that clearly state the specific permissible reasons for each policy, adhering to all statutory notice periods. Option D. Offer all policyholders in the identified high-risk geographic areas a significant premium increase for renewal, with the expectation that many will decline, thereby reducing the overall exposure without formal non-renewal. The correct answer is B. Issue non-renewal notices to all policyholders in the identified high-risk geographic areas, citing general underwriting concerns, and provide the minimum notice period required by state law. Explanation. This scenario presents a professional challenge because it requires an insurance professional to navigate the complexities of policy cancellation and renewal, balancing the insurer's business needs with the policyholder's rights and expectations, all within the strict confines of applicable state insurance regulations. The pressure to maintain profitability and manage risk can sometimes conflict with the obligation to provide clear, timely, and legally compliant communication regarding policy status. The professional must exercise careful judgment to ensure all actions are both ethically sound and legally defensible. The correct approach involves adhering strictly to the statutory notice periods and specific content requirements for non-renewal or cancellation notices as mandated by the relevant state's insurance code. This includes providing the policyholder with adequate advance warning, clearly stating the reasons for non-renewal or cancellation, and informing them of their right to request further information or appeal the decision, if applicable. This approach is correct because it directly aligns with the regulatory framework designed to protect consumers from arbitrary or unfair termination of insurance coverage. Failure to comply with these statutes can result in regulatory penalties, legal action, and damage to the insurer's reputation. An incorrect approach would be to cancel or non-renew a policy without providing the legally required notice period. This fails to give the policyholder sufficient time to secure alternative coverage, potentially leaving them uninsured and in violation of legal requirements, e.g., auto insurance. This action directly contravenes state statutes that specify minimum notice periods to prevent undue hardship on consumers. Another incorrect approach would be to provide a cancellation or non-renewal notice that is vague or fails to state the specific reason for the action. Many state regulations require a clear and concise explanation of the grounds for non-renewal or cancellation. Omitting this information prevents the policyholder from understanding the insurer's decision and from potentially addressing the underlying issues, and it violates the spirit and letter of consumer protection laws. A third incorrect approach would be to attempt to cancel a policy midterm for reasons not permitted by the policy contract or state law, or to fail to follow the prescribed cancellation procedure outlined in the policy and statutes. This could involve improper notice, failure to return unearned premium, or cancellation for discriminatory reasons. Such actions undermine the contractual agreement and violate regulatory prohibitions against unfair or discriminatory practices. The professional decision-making process for similar situations should begin with a thorough understanding of the specific policy terms and conditions, as well as the applicable state insurance laws and regulations governing cancellations and renewals. Before taking any action, the professional must consult these resources to determine the permissible grounds for action, the required notice periods, and the specific content that must be included in any communication to the policyholder. Documentation of all communications and actions taken is crucial. If there is any ambiguity or uncertainty, seeking guidance from legal counsel or the compliance department is essential to ensure adherence to all legal and ethical obligations. Question 14. Process analysis reveals that an insured manufacturer of electronic components has been sued by a third party, alleging that a defect in the insured's component, incorporated into a larger product, caused significant property damage. The insured has submitted a claim to its commercial general liability insurer. Which of the following represents the most appropriate approach for the insurer to take in evaluating this claim under U.S. law? Option A. Assume full coverage for the claim and proceed with defense and indemnity without a detailed examination of the policy's specific exclusions related to product liability. Option B. Immediately deny coverage because the claim involves a product defect, which is outside the scope of a standard commercial general liability policy. Option C. Conduct a thorough review of the commercial general liability policy's insuring agreements, definitions, and exclusions and analyze the claim under applicable U.S. product liability legal theories, e.g., negligence, strict liability, breach of warranty, to determine if the alleged defect and resulting damage are covered. Option D. Advise the insured that product liability claims are too complex to be covered under their policy and that they should seek specialized product liability insurance. The correct answer is B. Immediately deny coverage because the claim involves a product defect, which is outside the scope of a standard commercial general liability policy. Explanation: this scenario is professionally challenging because it requires an insurance professional to navigate the complex interplay between product liability law and the specific contractual obligations and disclosures within an insurance policy. The challenge lies in accurately assessing the insurer's potential liability when a product defect causes harm, considering the policy's coverage grants, exclusions, and conditions, all within the framework of U.S. product liability law as it would apply to an insurance contract. Careful judgment is required to ensure that the insurer's response aligns with both legal obligations and ethical duties to the insured. The correct approach involves a thorough review of the insurance policy's terms and conditions, specifically focusing on the insuring agreements, definitions of covered events, and any exclusions or limitations related to product liability claims. This review must be conducted in conjunction with an understanding of relevant U.S. product liability legal principles, such as negligence, strict liability, and breach of warranty. Determine if the alleged defect falls within the scope of coverage. The insurer must then communicate its coverage position clearly and promptly to the insured, adhering to state-specific unfair claims settlement practices acts and the policy's notice provisions. This approach is correct because it prioritizes adherence to the contractual agreement between the insurer and the insured, while also respecting the legal framework governing product liability. It ensures that the insured receives appropriate coverage as agreed upon, and that the insurer manages its risk exposure in a legally compliant and ethically sound manner. An incorrect approach would be to deny coverage solely based on the fact that the claim involves a product defect, without a detailed analysis of the policy language and applicable law. This fails to acknowledge that many commercial general liability policies are designed to cover liability arising from such defects, subject to specific exclusions. This approach risks violating the policy contract and potentially engaging in unfair claim settlement practices by improperly denying a covered claim. Another incorrect approach would be to assume coverage for all product liability claims without scrutinizing the policy's exclusions. Many policies contain specific exclusions for certain types of product defects, intentional acts, or claims arising from the insured's failure to recall defective products. Failing to consider these exclusions could lead to an overestimation of coverage and potential disputes with the insured or reinsurers. This approach is ethically problematic, as it could lead to the insurer being obligated to pay claims that were specifically excluded from coverage. A third incorrect approach would be to delay the investigation and coverage determination indefinitely, citing the complexity of product liability law. While product liability cases can be complex, insurance contracts typically require prompt investigation and communication regarding coverage. Unreasonable delays can violate state insurance regulations regarding timely claims handling and may constitute bad faith. This approach erodes trust and can expose the insurer to additional penalties and damages. Professionals should adopt a decision-making framework that begins with a comprehensive understanding of the insurance policy's terms and conditions. This should be followed by a diligent investigation of the facts giving rise to the claim, including the nature of the product defect and the alleged harm. Simultaneously, professionals must research and apply the relevant U.S. product liability laws that would govern the underlying claim. The coverage decision should then be made by comparing the facts of the claim against the policy's insuring agreements and exclusions, informed by the applicable legal principles. Finally, all coverage decisions and communications with the insured must be documented thoroughly and adhere to all regulatory requirements for claims handling and communication. Question 15. Market research demonstrates that a successful independent insurance agency, currently operated as a general partnership by two seasoned agents, is poised for significant growth. To capitalize on this opportunity, the agency seeks to bring in two new individuals who will contribute substantial capital and bring valuable marketing expertise. The existing partners wish to retain primary control over daily operations and strategic decision-making, while the new investors are primarily interested in a return on their investment and wish to limit their personal financial exposure to the amount of their capital contribution. Which of the following partnership structures would best align with the stated objectives and legal considerations for the agency? Option A. A new general partnership formed by all four individuals, with a detailed operating agreement specifying limited liability for the new investors. Option B. A joint venture agreement that outlines capital contributions and profit sharing without formal partnership registration. Option C. A general partnership, admitting the new individuals as equal partners in the existing general partnership. Option D. A limited partnership, with the existing agents acting as general partners and the new investors as limited partners. The correct answer is D. A limited partnership, with the existing agents acting as general partners and the new investors as limited partners. Explanation. This scenario presents a professional challenge because it requires an insurance professional to navigate the complexities of partnership structures and their implications for liability and operational control, particularly when considering the introduction of new capital and expertise. The decision hinges on understanding the fundamental differences between general and limited partnerships and how these distinctions impact the rights and responsibilities of the partners. Careful judgment is required to ensure the chosen structure aligns with the business objectives while adhering to legal and ethical obligations. The correct approach involves establishing a limited partnership. This structure is appropriate because it allows for the introduction of new investors who contribute capital and expertise but are shielded from personal liability beyond their investment. The general partner, S, retain operational control and bear unlimited liability, which is a standard characteristic of this partnership form. This approach is professionally sound, as it balances the need for growth and external input with the protection of individual partners from excessive risk, aligning with principles of prudent business management and adherence to partnership law. An incorrect approach would be to form a general partnership with the new investors. This is professionally unacceptable because it exposes all partners, including those who are primarily passive investors, to unlimited personal liability for the business's debts and obligations. This fails to protect the new investor's personal assets and contradicts the common expectation of limited liability for those contributing capital without active management. Another incorrect approach would be to structure the arrangement as a joint venture without clearly defining the roles and liabilities of each party. While a joint venture can be a flexible arrangement, without proper legal documentation, it can inadvertently create a general partnership, leading to unintended unlimited liability for all participants. This lack of clarity is professionally risky and can lead to disputes and legal complications. Finally, attempting to create a hybrid structure that mimics limited liability for all partners without formally establishing a limited partnership or a corporate entity would be professionally unsound. This would likely be deemed ineffective by courts, leaving all partners exposed to unlimited liability, and would demonstrate a disregard for established legal frameworks designed to provide clarity and protection. The professional decision-making process for similar situations should involve a thorough understanding of the client's business goals, risk tolerance, and desired level of involvement for each party. This should be followed by consultation with legal counsel to ensure the chosen business structure complies with all applicable partnership laws and provides the intended protections and operational framework. Professionals must prioritize clarity, legal compliance, and the protection of their clients' interests. Question 16. The performance metrics show a significant increase in the number of insurance policies sold across state lines, prompting a discussion about whether federal or state regulators have primary oversight for consumer protection related to these sales. Which approach best reflects the current regulatory framework for insurance in the United States? Option A. Insurance sales across state lines are exclusively regulated by federal law, as this falls under interstate commerce and preempts all state-level consumer protection regulations. Option B. State insurance departments have primary regulatory authority over consumer protection in insurance sales, even for policies sold across state lines, unless a specific federal law clearly preempts state authority. Option C. A new federal insurance commission has been established to create a uniform set of consumer protection laws that supersede all state-specific regulations for interstate insurance sales. Option D. Federal agencies, such as the Consumer Financial Protection Bureau, have assumed primary regulatory authority over all aspects of consumer protection in insurance sales due to the interstate nature of modern transactions. The correct answer is B. State insurance departments have primary regulatory authority over consumer protection in insurance sales, even for policies sold across state lines, unless a specific federal law clearly preempts state authority. Explanation. This scenario presents a professional challenge because insurance regulation in the United States is a complex, dual system. Professionals must navigate the interplay between state and federal oversight, understanding which entity has primary authority over specific insurance activities. Misinterpreting this division can lead to significant compliance failures, fines, and reputational damage. Careful judgment is required to identify the appropriate regulatory body for any given insurance practice. The correct approach involves recognizing that, under the McCarran-Ferguson Act, states retain primary regulatory authority over the business of insurance. Federal law generally applies only to specific areas that states cannot effectively regulate, such as certain aspects of interstate commerce or areas where federal interests clearly supersede state ones. Therefore, when an insurance practice falls squarely within the traditional scope of insurance regulation, state law and state regulatory bodies are the primary point of reference. This approach ensures compliance with the established framework and respects the historical division of regulatory power. An incorrect approach that focuses solely on federal oversight without considering state authority fails to acknowledge the McCarran-Ferguson Act and the foundational principle of state regulation. This can lead to overlooking critical state-specific requirements, such as licensing, policy form approvals, and market conduct examinations, resulting in violations of state law. Another incorrect approach that attempts to apply federal regulations to every aspect of insurance business, even when state law is clearly applicable, demonstrates a misunderstanding of the dual regulatory system. This can result in unnecessary compliance burdens or, conversely, a failure to comply with state mandates because the focus is misplaced on federal requirements that may not even apply. A third incorrect approach that assumes a complete federal takeover of insurance regulation ignores the historical and legal precedent that reserves primary authority to the states. This leads to a flawed understanding of the regulatory landscape and potential noncompliance with the dominant state-level rules governing most insurance operations. The professional decision-making process for similar situations should begin with identifying the specific insurance activity in question. Then, determine whether that activity falls under the traditional definition of the business of insurance as understood by state law. If it does, state regulations and the state insurance department are the primary authorities. If the activity involves interstate commerce in a way that states cannot effectively regulate, or if there is a specific federal statute that explicitly grants federal authority over that aspect of insurance, then federal oversight becomes relevant. This systematic evaluation ensures that the correct regulatory framework is applied, promoting compliance and ethical conduct. Question 17. Quality control measures reveal that a claims adjuster handling a bodily injury claim arising from an automobile accident in a state with modified comparative fault rules and a statutory cap on non-economic damages is evaluating the claimant's potential recovery. The adjuster is considering the claimant's medical expenses, lost wages, and pain and suffering. The adjuster is aware of the state's tort reform legislation, but is unsure how to precisely apply the modified comparative fault rules to reduce the award if the claimant is found partially at fault, and how the cap on non-economic damages will limit the total recovery for pain and suffering. The adjuster's initial assessment of damages for pain and suffering, before considering fault or caps, is $150,000. The state's statutory cap on non-economic damages is $100,000. Preliminary investigation suggests the claimant may be 30% at fault for the accident. Which of the following approaches best reflects the proper application of the jurisdiction's tort reform measures in assessing the claimant's potential recovery? Option A. Calculate the claimant's total economic damages and add the statutory cap for non-economic damages, then reduce the total by the claimant's percentage of fault. Option B. Calculate the claimant's total economic damages and add the statutory cap for non-economic damages, then reduce the non-economic damages by the claimant's percentage of fault, and finally reduce the total by the claimant's percentage of fault. Option C. Calculate the claimant's total economic damages and add the claimant's pain and suffering damages, then reduce the pain and suffering damages by the statutory cap, and finally reduce the remaining total by the claimant's percentage of fault. Option D. Calculate the claimant's total economic damages and add the claimant's pain and suffering damages, then reduce the pain and suffering damages by the claimant's percentage of fault, and finally reduce the total by the statutory cap. Correct answer is A. Calculate the claimant's total economic damages and add the statutory cap for non-economic damages, then reduce the total by the claimant's percentage of fault. Explanation. This scenario is professionally challenging because it requires an insurance professional to navigate the complexities of tort reform's impact on liability and damages, specifically within the context of the CPCU 530 exams jurisdiction, which is assumed to be the United States for this purpose. The professional must balance the insurer's financial interests with the legal and ethical obligation to policyholders and claimants, all while adhering to specific state tort reform statutes. Careful judgment is required to ensure that claims handling practices do not violate these statutes or lead to unfair outcomes. The correct approach involves a thorough understanding of the specific tort reform measures enacted in the relevant jurisdiction and their direct application to the claims at hand. This includes recognizing how caps on non-economic damages, modified comparative fault rules, or limitations on punitive damages might affect the insurer's exposure and the claimant's recovery. By applying these specific statutory limitations to the facts of the claim, the insurer can accurately assess its liability and negotiate a settlement or proceed with litigation in a manner consistent with the law. This approach is justified by the fundamental principle of adhering to applicable laws and regulations, which are paramount in insurance operations. Furthermore, it aligns with the ethical duty to handle claims fairly and in good faith, which includes not overpaying claims due to a misunderstanding of legal limitations, nor underpaying them by ignoring valid legal arguments. An incorrect approach would be to disregard the specific tort reform statutes, perhaps by relying on outdated claims handling practices, or by assuming a claimant's potential recovery without considering the statutory limitations. This failure to acknowledge and apply the relevant tort reform laws constitutes a regulatory failure, as it directly contravenes the statutory framework governing liability and damages. Ethically, it could lead to unfair outcomes for both the insured by potentially increasing premiums due to excessive payouts, and the claimant, if their recovery is unfairly reduced due to an incorrect application of the law. Another incorrect approach would be to apply tort reform measures from a different jurisdiction. This is a critical regulatory failure because insurance law is largely state-specific, and tort reform statutes vary significantly from one state to another. Applying the wrong set of laws would lead to incorrect liability assessments and potentially expose the insurer to legal challenges and regulatory penalties. Ethically, It demonstrates a lack of diligence and professional competence. A third incorrect approach would be to interpret tort reform statutes in a manner that is overly favorable to the insurer, even if that interpretation is not supported by case law or the plain language of the statute. This could be seen as an attempt to circumvent the intent of the tort reform legislation, leading to regulatory scrutiny and potential bad faith claims. Ethically, it violates the principle of acting in good faith and fair dealing with all parties involved in the claims process. The professional decision-making process for similar situations should begin with identifying the specific jurisdiction governing the claim. Next, the professional must research and understand the applicable tort reform statutes within that jurisdiction. This involves consulting legal counsel or specialized claims resources to ensure accurate interpretation. The facts of the claim should then be analyzed in light of these specific statutory provisions to determine the potential liability and appropriate settlement range. Throughout the process, maintaining clear documentation of the legal basis for decisions is crucial. Question 18. Benchmark analysis indicates that insurance professionals often face situations where the exact moment of contract formation is critical for determining coverage. Considering the principles of contract law as applied in the United States insurance industry, which of the following best describes the formation of a binding insurance contract when an applicant submits an application and pays the initial premium? Option A. A binding contract is formed upon the applicant's submission of a completed application and payment of the initial premium, provided the application does not contain any explicit conditions for acceptance. Option B. A binding contract is formed when an insurance agent verbally assures the applicant that coverage is effective immediately upon submission of the application and premium. Option C. A binding contract is formed solely based on the applicant's intent to obtain insurance, as evidenced by the submission of an application and premium payment. Option D. A binding contract is formed when the insurer unconditionally accepts the offer, typically by issuing a policy or a binder, after reviewing the application and assessing the risk. The correct answer is A. A binding contract is formed upon the applicant's submission of a completed application and payment of the initial premium, provided the application does not contain any explicit conditions for acceptance. Explanation: this scenario is professionally challenging because it requires an insurance professional to navigate the nuances of contract law, specifically concerning the formation of a valid insurance contract, while adhering strictly to the regulatory framework governing the CPCU 530 exam. The core of the challenge lies in identifying the precise moment and conditions under which an offer and acceptance create a binding agreement, considering the unique aspects of insurance applications. Careful judgment is required to distinguish between preliminary discussions or conditional commitments and a fully executed contract. The correct approach involves recognizing that a binding insurance contract is formed when there is a clear offer, unconditional acceptance, and consideration, all within the bounds of applicable state insurance laws and contract principles. In the context of an insurance application, the application itself is typically an offer, and the insurer's unconditional acceptance, usually through the issuance of a policy or a binder, constitutes the acceptance. Premium paid serves as consideration. This approach aligns with fundamental contract law principles and the regulatory expectation that insurance contracts are formed through a clear offer and acceptance process, ensuring clarity for both the insured and the insurer. An incorrect approach would be to assume a contract is formed based solely on the applicant's submission of an application and payment of a premium, without explicit insurer acceptance. This fails to acknowledge that the insurer has the right to underwrite the risk and may reject the application. Legally, this constitutes an incomplete contract formation, as the acceptance element is missing. Another incorrect approach is to rely on verbal assurances from an agent that coverage is in place before formal policy issuance or a binder is provided. While agents can bind coverage in some circumstances, such authority is often limited and must be exercised within specific regulatory guidelines. Without a formal binder or policy, such verbal assurances do not create a legally binding contract and can lead to significant regulatory violations and consumer protection issues. A third incorrect approach is to consider the application and premium payment as an automatic acceptance by the insurer, regardless of any underwriting conditions or explicit policy issuance. This ignores the insurer's right to accept or reject the risk and the legal requirement for mutual assent to the terms of the contract. Professionals should employ a decision-making framework that prioritizes clear offer and acceptance. This involves understanding the typical stages of insurance contract formation, the applicant's offer application, the insurer's underwriting process, and the insurer's acceptance, policy issuance, or binder. Professionals must always verify that all elements of a valid contract are present and that any binding commitments are documented according to regulatory requirements. When in doubt, seeking clarification from underwriting or legal counsel is paramount to ensure compliance and avoid misrepresenting the existence of coverage. Question 19. Strategic planning requires an insurance professional to consider potential conflicts of interest when recommending third-party services to clients. An insurance agent, M.S. Evans, has a long-standing client who requires specialized estate planning services. M.S. Evans knows a reputable attorney who offers such services and has a referral agreement with this attorney, whereby M.S. Evans receives a small commission for each client referred. M.S. Evans believes the attorney is highly competent and would serve her client well. What is the most appropriate course of action for M.S. Evans to uphold her professional obligations? Option A. Refer the client to the attorney without mentioning the referral agreement or commission, as the attorney is competent and it is in the client's best interest. Option B. Refer the client to the attorney and only disclose the commission if the client specifically asks about referral fees. Option C. Inform the client about the referral agreement and the commission she will receive, and allow the client to decide whether to proceed with the referral. Option D. Decline to refer the client to the attorney to avoid any perception of a conflict of interest, even if it means the client may not access the best available service. The correct answer is A. Refer the client to the attorney without mentioning the referral agreement or commission, as the attorney is competent and it is in the client's best interest. Explanation. This scenario presents a professional challenge due to the inherent conflict between an insurance professional's duty to their client and the potential for personal financial gain through a referral. The professional liability or malpractice in this context arises from a breach of fiduciary duty and potentially negligent advice if the referral is not solely in the client's best interest. Careful judgment is required to navigate this situation ethically and legally, ensuring that client welfare remains paramount. The correct approach involves transparently disclosing the referral arrangement and any potential financial benefit to the client, allowing the client to make an informed decision. This aligns with the ethical principles of honesty, integrity, and acting in the client's best interest, which are foundational in professional liability. Regulatory frameworks, such as those governing insurance professionals, often mandate disclosure of conflicts of interest to prevent situations where personal gain might influence professional judgment. This approach upholds the professional's duty of care and loyalty. An incorrect approach would be to make the referral without any disclosure, hoping the client will not discover the arrangement. This constitutes a breach of fiduciary duty and potentially fraudulent misrepresentation, exposing the professional to claims of malpractice. Ethically, it violates the principle of honesty and transparency. Another incorrect approach is to rationalize the referral by believing the referred service is superior, without disclosing the personal benefit. While the service might be good, the lack of disclosure creates a hidden conflict of interest and undermines the client's trust and autonomy. This still falls short of the required transparency and can lead to claims of negligence if the client later discovers the undisclosed benefit and feels misled. A third incorrect approach is to refuse to refer altogether, even if the referred service is demonstrably the best option for the client, solely to avoid any appearance of impropriety. While this avoids the conflict, it may not be in the client's best interest and could be construed as a failure to provide competent advice if the professional has a duty to explore all viable options for the client. Professionals should employ a decision-making framework that prioritizes client interests, adheres to all disclosure requirements, and proactively identifies and manages potential conflicts of interest. This involves a clear understanding of their fiduciary responsibilities and the relevant regulatory landscape governing professional conduct. When faced with a potential conflict, the professional should err on the side of overdisclosure and seek guidance if unsure. Question 20. The efficiency study reveals a significant decline in profitability and market share for Insure Corp., a U.S.-based insurance company operating as a C corporation. The board of directors is considering dissolving the company. Which of the following actions best represents the legally and ethically sound approach to initiating the dissolution process? assuming Insure Corp is incorporated in a state with typical corporate statutes. Option A. Convene a board meeting to formally approve a resolution to dissolve the corporation, followed by seeking shareholder approval as required by state law and the company's bylaws, and then initiating the statutory winding-up process. Option B. Inform the state's insurance regulatory body of the intention to cease operations and await their instructions on how to proceed, without necessarily involving shareholders at this initial stage. Option C. Immediately cease all business operations and begin liquidating assets to distribute proceeds to shareholders as quickly as possible. Option D. Transfer all remaining assets to a newly formed entity controlled by the current management team, effectively abandoning the existing corporate shell. The correct answer is C. Immediately cease all business operations and begin liquidating assets to distribute proceeds to shareholders as quickly as possible. Explanation: the efficiency study reveals a significant decline in profitability and market share for Insure Corp, a U.S.-based insurance company operating as a C corporation. The board of directors is considering various strategic options, including dissolution. This scenario is professionally challenging because the dissolution of a business entity, especially a publicly traded one like Insure Corp, involves complex legal, financial, and ethical considerations. The board must navigate state corporate law, federal tax regulations, securities laws, and fiduciary duties to shareholders and other stakeholders. A hasty or improperly executed dissolution can lead to significant legal liabilities, reputational damage, and financial penalties. Careful judgment is required to ensure compliance with all applicable regulations and to act in the best interests of the company and its stakeholders. The correct approach involves a structured, legally compliant dissolution process. This typically begins with a formal decision by the board of directors, followed by shareholder approval as required by state law and Insure Corp's articles of incorporation. The process then mandates winding up the business affairs, which includes ceasing operations, collecting assets, paying debts and liabilities, and distributing any remaining assets to shareholders. This approach is correct because it adheres strictly to the principles of corporate governance and state dissolution statutes, such as those found in Delaware General Corporation Law, DGCL. If Insure Corp is incorporated there, or the relevant state's corporate code, it ensures that all creditors are protected, legal obligations are met, and shareholders receive their rightful distribution, thereby minimizing legal risk and fulfilling fiduciary duties. An incorrect approach would be to simply cease operations without formally dissolving the entity. This failure to follow the statutory dissolution procedures would leave Insure Corp technically in existence, potentially exposing its directors and officers to ongoing liabilities and regulatory scrutiny. It would also prevent the orderly distribution of assets and settlement of claims, leading to potential lawsuits from creditors and shareholders. Another incorrect approach would be to prioritize immediate asset liquidation and distribution to shareholders without first satisfying all known debts and liabilities. This violates fundamental principles of corporate law and creditor protection. Creditors have a legal right to be paid before shareholders receive any distribution, and failure to do so can result in personal liability for directors and officers who approved such a distribution. A third incorrect approach would be to attempt a dissolution that circumvents necessary shareholder approvals. This would be a direct violation of corporate governance requirements and state law, rendering the dissolution invalid and potentially leading to legal challenges from disgruntled shareholders. It undermines the democratic principles of corporate ownership and can result in significant legal repercussions. The professional decision-making process for such situations should involve assembling a team of legal counsel specializing in corporate law and tax, financial advisors, and potentially an investment banker. This team should conduct a thorough analysis of the company's financial position, legal obligations, and the most advantageous dissolution strategy. The board must then meticulously follow the statutory requirements for dissolution, ensuring transparency with shareholders and compliance with all regulatory filings. This systematic and legally sound approach protects the company, its stakeholders, and the individuals making the decisions.